Hello, hello, hello. Today is the day, y'all. Let me just tell y'all, I knew as soon as I hopped my booty in the shower that the orders were going to come down. I've been up since 6:30 and I have been refreshing that page since 6:32. Okay? Thinking maybe I missed it, maybe all of the things. Listen, I know that other people have read it and stuff, but we want to read it together. So if we could do no spoilers in the chat, that'd be fantastic. Please. I would appreciate that. Okay? So I just want to put that out there before we get started because I know that I'm late because I was in the shower like a crazy person. Whew, okay, so let's get started. Let me get over here to the order. So let's start. We're going to start with the first, the least important order, which is the hairs. Okay, makeup and all those things. Okay, because I like to let everybody. I went live spur of the moment, and I also, so that doesn't give YouTube a whole lot of time, and they really like at least 30 minutes to send out notifications. So I just want to make sure that everybody gets to hear the part they really care about, which is the motion to suppress. So we're going to start with the motion that Sarah probably cares about, but that's about it. All right, I have added it to the stream. Let's get going. Here we go. All right. Order on defendant's motion for right to hair, cosmetics, and civilian clothing without restraints at trial. All right. A, the court provided ore tennis ruling on October 3rd, 2024. I think that's how you say that word. I'm not a Latin speaker. Regarding defendant appearing in civilian clothing for trial and defendant's access to cosmetics and hairstyling throughout the trial. The court reserved ruling on defendant appearing before the judge free from physical restraints. So this is new. Sarah was fine with having the stun shackle around her ankle. So but the defense has said, no. We don't even want that. We want nothing. Okay. In deciding whether to physically restrain a defendant and what method to use, the court must balance its obligation to maintain courtroom safety against the risk, quote, that certain security measures may impair the defendant's presumption of innocence. D, a court may order physical restraints only if it is found to be necessary to maintain the security of the courtroom. Before ordering a defendant shackled at trial, the court must make a case-specific and individualized assessment that considers, one, the defendant's criminal history and the nature of the pending charges, with special attention to whether either involve violent acts. Two, whether the defendant has disrupted criminal proceedings in the past, and three, whether the defendant has engaged in any threatening behavior. There was no evidence that the defendant has any criminal history. The defendant is charged by way of an information filed on 03/23/2020 with a single count of second-degree murder. There is no evidence that the defendant has disrupted criminal proceedings in the past or has been contumacious defendant during court proceedings. There's no evidence that the defendant has engaged in any threatening behavior. Orders and adjudges as follows. The motion is hereby granted. Defendant's shackles and cuffs be removed during trial proceedings. Done and ordered. Okay. Now, for the one we've all been waiting for. Here we go. Are we all ready? Yes. Okay. Here we go. I'm nervous. All right. Order on defendant's motion to suppress defendant's statements at OCSO, on defendant's amended motion to suppress defendant's statements at OCO, and on defendant's second amended motion to suppress defendant's statements at OCO. And then it's going to read the cause. Let me make this a little bit bigger for me. All right. This cause came before the court on October 2nd, 2024, on the defendant's motion to suppress defendant's statements, e-filed 9/24/2024, the motion. On the state's motion to strike, defendant's motion to suppress statements at OCO, and state's response to defendant's motion to suppress statements e-filed 09/27/2024, the response. On the defendant's amended motion to suppress defendant's statements at OCSO e-filed on 9/30/2024, the amended motion, and on defendant's second amended motion to suppress defendant's statements at OCSO e-filed 10/2/2024, the second amended motion. The court, having reviewed the motion, having reviewed the response, having reviewed the amended motion, having reviewed the second amended motion, having reviewed the court file, having considered the testimony and evidence offered by the parties, having considered the arguments offered by counsel for the state, and having considered the arguments offered by counsel for defendant, finds as follows. A. Defendant Sarah Boone is charged by way of an information filed 3/23/2020 with a single count of second-degree murder. On February 24th, 2020, defendant called 911 after finding her boyfriend, George Torres, deceased. C. Deputy Kayla Rodriguez arrived on February 24th, 2020 and spoke to defendant. C also states Exhibit 1. D. Detective Kepsel, a homicide detective with the Orange County Sheriff's Office, OCSO, with 6 years experience as a homicide detective and a law enforcement officer since 2013, was the lead investigator of George Torres's death on February 24th, 2020. Detective Kepsel arrived at the scene within 30 minutes to an hour of OCSO deputies arriving, was briefed, and performed a walkthrough of the apartment. Thereafter, a search warrant was drafted. Detective Kepsel then made contact with the defendant outside of apartment for a few minutes and explained procedures of the search warrant. The search warrant was executed with CSI. Defendant's cell phone was collected after CSI documented the scene. Detective Kepsel wanted to go through defendant's cell phone to corroborate defendant's story. Defendant signed a consent prior to the February 24th, 2020 interviews addressed below. See also Defendant's Exhibit 1. Detective Kepsel did not look at defendant's cell phone, including any videos, prior to the interviews addressed below, as digital forensics did not arrive until approximately 7:00 p.m. Detective Kepsel then made contact with defendant's ex-husband, Brian Boone. Thereafter, Detectives Kepsel and Lowen had an interview with defendant in Detective Kepsel's unmarked Nissan Pathfinder at approximately 5 p.m. See also states Exhibit 1. Detective Kepsel explained that she wanted to have a conversation with defendant after walking the apartment. Detective Kepsel testified that she would not have interviewed defendant outside of the unmarked vehicle, had no memory of using the words routine, and that everything was explained on the recording. The routine is not used by Detective Kepsel in any recording. See states Exhibit 1. Detective Kepsel explained the purpose of this interview, including defendant's prior conversations with Deputy Kayla Rodriguez and Detective Kepsel, and Detective Kepsel's desire to, quote, to get a, quote, further understanding of what happened last night and ask defendant more detailed questions, end quote. See states Exhibit 1. Thereafter, Detective Kepsel began reading Miranda's as follows. Detective Kepsel, I am going to read you your rights because I am going to read you your rights, but it's just because that's how we do things, okay? You do have the right to remain silent, okay? Do you understand that? Defendant, yes. Detective Kepsel, anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before question without charge. Has anyone threatened you or promised you anything to get you to talk to me? Defendant, no. Detective Kepsel, do you understand what I just read you? Defendant, yes. Therefore, after Detective Kepsel interviewed the defendant again after the initial digital recorder's memory was full, see exhibit, a second separate recording was initiated. Detective Kepsel confirmed with the defendant that no additional communications occurred prior to the second separate recording, and Detective Kepsel inquired of the defendant prior to asking any other questions. You do understand that you don't have to speak with me if you don't want to, correct? To which defendant responded, yes. After concluding, After concluding the interviews, but before leaving, Detective Kepsel had conversations with defendant had, well, about coming in OCSO the next day to address the pending autopsy, and that Detective Kepsel would have more questions. Detective Kepsel did not recall speaking about defendant's cell phone, but had defendant asked about getting the cell phone back, Detective Kepsel would not have given a specific time frame for returning defendant's cell phone. Detective Kepsel had no memory of receiving a call from defendant on the evening of February 24th, 2020. Defendant's testimony largely agreed with Detective Kepsel's testimony, including the timeline of calling 911, speaking with Deputy Kayla Rodriguez, and speaking with Detective Kepsel. As to the February 24th, 2020 interviews, defendant confirmed that Detective Kepsel explained, oh wait, hold on. I want to read this right here. During this the second separate recording, defendants used higher tier words, including compos mentis. Oh, Sarah. All right. Detective Kepsel explained that general questions would be asked. Defendant confirmed that she stayed on the scene 10 plus hours while the investigation was performed. Defendant's own testimony was that, this is going to hurt her, you guys. She was under the influence of alcohol from the night before at approximately, I think this is to be 10 p.m. the next day. Or 1 p.m. That's what it is. At approximately 1 p.m. the next day. I'm sorry, you guys. I'm not all the way awake, and I'm really nervous because I'm wanting to get through this. However, there was nothing evidencing defendant being intoxicated or under the influence of alcohol when clearly speaking and interacting with Deputy Kayla Rodriguez. See Exhibit 1. J. Defendant's statement of making a call to Detective Kepsel between 9:30 p.m. and 10 p.m. on February 24th, 2020 from her ex-husband's home does not line up with defendant's own timeline of staying at the scene 10 plus hours, which began at approximately 1 p.m. The court finds this statement lacks credibility. Boom. Okay. Defendant claimed that before they left the scene, Detective Kepsel or Lowen would return defendant's cell phone to the apartment. On February 25th, 2024, defendant claims that defendant and Detective Kepsel had a discussion regarding the picking up of the defendant's cell phone, specifically that due to Detective Kepsel's pregnancy, the defendant needed to come down to OCSO to pick up the cell phone. Defendant's sole reason for traveling to OCSO was to pick up the cell phone. Number 3, approximately 1 hour and 27 minutes into the February 25th, 2020 interview, defendant returns to her list of prepared written questions and specifically asks, quote, "Am I getting my phone back?" See States Exhibit 1. This prepared written question would not be asked if one was told to come pick up a cell phone. like I said the other day, whenever that live was, where we went over that. Okay, my bad. Let me be professional. The court finds defendant's statement regarding picking up the cell phone also lacks credibility. L. On February 25th, 2020, after Detective Kepsel reviewed some of the extraction of defendant's cell phone by digital forensics and attended the autopsy, Detective Kepsel requested defendant to come to OSCO's office. Detective Kepsel did not want to approach defendant in front of her child at her ex-husband's home. Defendant's worry and concern about her son was addressed with Deputy Kayla Rodriguez. See also State's Exhibit 1. M. The state and the defense agree that the February 25th, 2020 interview was custodial. N. The pith of defendant's argument is contained in this exchange during the beginning of the February 25th, 2020 interview. Detective Kepsel, just let us know if at any time you need water, okay? I'm going to have you sit in the green chair. Oh, the green chair. Detective Kepsel, appreciate you coming in. Defendant, yes, ma'am. I want to ask about these when we have a moment, referring to her pre-prepared written questions. Detective Kepsel, sure. So, obviously, he received his autopsy. So, I'm going to read you your rights again because we have to talk about that. And since I'm talking to you, since I'm talking about the incident, we just have to do it. All right, annotation 4. The court notes that this statement is an accurate statement of the law. See Wright versus State. While Detective Stroop said, this is something I have to do when giving the Miranda warnings. This is an accurate statement of the law, as law enforcement officers are required to administer Miranda warnings prior to custodial interrogations. Back up here. Just like we did yesterday. Defendant, normal protocol. Detective Kepsel, just like we did yesterday. Remember, I read you the rights. Defendant, yeah. Detective Kepsel, yeah, it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? Defendant, sure. Detective Kepsel, all right. So you have the right to remain silent. Anything you say may be used against you in court. You have a right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? Defendant, no. Detective Kepsel, and do you understand what I just read you? Defendant, yes. See State's Exhibit 1. Whether the Miranda warning sufficient. O, the Fifth Amendment of the United States Constitution and Article 1, Section 9 of the Florida Constitution both provide for a right against self-incrimination. The self-incrimination clause of Article 1, Section 9, Florida Constitution requires that prior to custodial interrogation in Florida, suspects must be told that they have a right to remain silent, that anything they say will be used against them in court, that they have a right to a lawyer's help, and that if they cannot pay for a lawyer, one will be appointed to help them. Check, check, check. She did all that. P, both the Florida Supreme Court and the United States Supreme Court have stressed that there is not talismanic incantation required to ensure that Miranda warnings are sufficiently conveyed. A court does not examine a Miranda warning as if construing a will or defining the terms of an easement. Okay, so all this is about the Miranda law. R, the Miranda warning given to defendant in the instant case is identical to the exemplary Miranda warning identified in Owen's Supra. S, as such, The Miranda warning given to defendant in the instant case was sufficient. 2. Whether the defendant's statements on February 25th, 2020 were coerced. To establish that a statement is involuntary, there must be a finding of coercive police conduct. And then it's Baker versus State. Generally, to determine whether a confession is involuntary and coerced, a court must examine the totality of the circumstances surrounding it. When the voluntariness of a confession is in dispute, it is the state's burden to prove voluntariness by a preponderance of the evidence. There were no misrepresentations of the law regarding any defense. See Johnson versus State. No directly or specifically made promises, no overt act or threat of force against the defendant was proved or claimed, no fear of material or physical harm, no hope of material reward, no indication that defendant was a newcomer to the law based on the 2 times Miranda warnings were provided between February 24th, 2020 and February 25th, 2020. No indication that the defendant is mentally deficient, especially considering the verbiage she used. No threats, delusions, deceptions, or promises, and defendant was offered water and breaks. There you have it. V. The judge is going to go through every letter. I love it. There were no false statements made by law enforcement in order to coerce defendant to go to OCSO's office on February 25th, 2020, based on the findings above. W. Under the totality of circumstances, defendant's statements on February 25th, 2020 were not coerced. Whether the defendant's statements on February 25th were voluntarily made. X. A statement is not compelled within the meaning of state or federal law if an individual voluntarily, knowingly, and intelligently waives his right to constitutional privilege. See Miranda versus Arizona. The state must prove by a preponderance of the evidence that a defendant's Miranda rights were waived. To constitute a voluntary waiver, the state must show, 1, that the waiver was the result of a free choice on the part of the defendant and not the product of intimidation, coercion, or deception, and 2, the waiver was made with a full awareness of the nature of the right being abandoned and the consequences of the abandonment. Only if the totality of the circumstances surrounding the interrogation reveals both an uncoerced choice and the requisite level of comprehension may a court properly conclude that Miranda rights have been waived. Why? Factors relevant to consider include 1, the manner in which the Miranda rights were administered, including any cajoling or trickery. There was no cajoling or trickery. 2, the suspect's age, experience, background, and intelligence. She used higher tier verbiage. She's also been arrested before and was there when other people have been arrested. So there you go. All right. 3, the fact that the questioning took place in the station house. And 4, the fact that the interrogators did not secure a written waiver of Miranda rights at the outset. Okay, Z. The Miranda rights were administered in a normal tone and cadence. There was no rushed or urgent speech. There was no delay in the administration of defendant's Miranda rights. The recorded February 25th, 2020 interview reflects that the defendant understood and acknowledged that she understood her rights. See State's Exhibit 1. Defendant acknowledged that she understood her rights. See ID. Evidence supported conclusion that defendant voluntarily waived rights to remain silent and obtain counsel when officer read defendant his rights and asked defendant whether he understood each of this rights, to which defendant responded affirmatively. AA. The court reincorporates its findings in U and V herein which further show no cajoling or trickery. BB, Defendant was 42 years old at the time she made the statements and appears to be of normal intelligence. See footnote 2 above. CC, the February 25th, 2020 interview did take place at OCSO's office and no written waiver was secured. DD, under the totality of circumstances, defendant's statement on February 25th, 2020 were made with a voluntary, knowing, and intelligent waiver, and this waiver was the result of a free choice on the part of the defendant and was not the product of intimidation, coercion, or deception, and that the waiver was made with full awareness of the nature of the rights abandoned. Orders and judges as follows. The motion, the amended motion, and the second amended motion are hereby denied in the formation. Denied. All the snaps. That's it. There we go. All right, let's see what else we got in here. Another evidence control sheet. All right. There you have it, you guys. That is that. The interrogation video comes in. That's all she wrote. Oh, I see something. Hold on just a second. Let me. Oh my God, Music City Mom. You don't have to do that, babe. Thank you very much. I appreciate that. If you guys got a gifted membership from Music City Mom, make sure that you thank her. That was really sweet of you, babe. I appreciate that. And I hope your birthday was fantastic. That was Music City Mom's birthday. No, that was it. Music City Mom's birthday. That was the other day. Mayla's mom's is this day. Was yesterday. Okay. Sorry. I'm a little thrown off. And I love that Judge Kraynick took the time to go through each and every element. That's how it's done, Mr. Owens, just for your future reference. When you want to make a salient, good argument and you want it to be heard and considered, you ought to say state case law, like Judge Kraynick did, because Judge Kraynick obviously was an attorney prior to being a judge. Okay? He knows the law. Bruh. Now, Music City Moms is on Halloween. It was Mayla's mom's that was the other day. My bad. I'm so sorry, babe. I'm so sorry. And Yana's was yesterday too. Well, let's just sing happy birthday right now to all the first week of October babies. Happy birthday to you. Happy birthday to you. Happy birthday, first week of October babies. Happy birthday to you. There you go. Oh, okay. Oh, Smokey Armstrong says, as an attorney, I can confidently say that the whoosh you're hearing is the state pulling any sweetheart plea deal it may have offered Sarah off the table. Boom shakalaka. Absolutely. Absolutely. That's it. That's all she wrote. Now, I want to talk a little bit about, Chick Tracy. You didn't have to do that, babe. Thank you for the super sticker. I appreciate that so much. Pretend judge says, my birthday is tomorrow. Everyone, parents, was busy New Year's Eve. LOL. I was due on February 14th. I was scheduled to be a Valentine's baby, but I was born January 28th. Okay. So, you know what? I want to say this really quickly before I forget. I'm so glad Smokey Armstrong. It's so nice to have an attorney on board watching, because I feel like sometimes I get stuff right, even though I'm not an attorney. And then sometimes I don't understand things and I need an attorney to explain it. So I'm glad that you are here. I appreciate you being here. And if you guys haven't done so, really quickly, would you give your girl a thumbs up or thumbs down, whatever you feel like I deserve for the reading? I don't judge and I won't be upset either way. Just one or the other, please. All right. Now, I have been reviewing the hearing yesterday, or, from not yesterday. See, I don't even know what day it is. Thank you, Sarah Boone. Okay, yesterday was Thursday from Wednesday's hearing. Okay, I've been reviewing Sarah's testimony, but more importantly, what I've been reviewing and listening to is Mr. J's arguments after her testimony, the closing, and in between when she was testifying. Now, it appears that Sarah has given conflicting statements during her evaluations by the state's expert witness, who's either a I can't remember if he or she is a psychiatrist or a psychologist. I know the difference, but I can't remember which one their expert is. That's my bad. I'll look it up and be ready to talk about it intelligently tonight. Now, she did not get her makeup. The thing is, she got the shackles and stuff removed, but the makeup was really discussed in that hearing we had on Wednesday. Lord Jesus, Jen, remember the day of the week. Maybe I should start wearing day of the week underwear so I'll remember. Sheesh. I'm telling you what. Anywho, that was unprofessional. I apologize. Because it's considered contraband. They don't even offer makeup at the commissary at the Orange County jail. And so if she were to leave with no makeup from the jail and they were to apply makeup in the courtroom, because that was the only place to do it, it poses a security issue. So the judge was like, no dice. Yeah, she did get it. She did get it. And then then an officer approached the bench and spoke to Judge Kraynick, and Judge Kraynick was like, psych, no makeup for you. So I'm telling you right now, we've had many, many suggestions on makeup alternative to conventional cosmetics. You may use, which is my personal favorite and my recommendation, hot Cheeto dust for both lipstick and blush. Okay. And I prefer the hot Cheeto dust over the Kool-Aid packet that has been suggested. You can mix either one of them with a little bit of Vaseline and you'll be all right. I suggest the hot Cheeto dust and not the Kool-Aid, because the Kool-Aid gives a deeper red, and a red lip, especially a bold red lip like that, sometimes doesn't play well in front of the jury. It's better to be more subtle. Okay. It's just my suggestion. Sarah, do with it what you will. My alternate suggestion is coffee grounds and Vaseline also make excellent mascara, I'm told, to and you can even use a little bit of it if you do it correctly. You can use a little bit of the mixture to do a little bit of an eyeliner. I would suggest not underlining the water eye, the waterline of your eye, Sarah, as women of a certain age can drag the face down. Not a good idea. Also, my suggestion for the hair. If I were you, I would save up any cans of Coca-Cola or any other soft drink. It doesn't necessarily have to be Coke. I don't know if the Orange County serves Coke products or Pepsi. It doesn't matter. It all works the same. If you drink the drink and then you cut the ends off, okay, rinse it out, let it dry, dampen your hair, okay, and then use them as rollers and sleep on it overnight. You got to, let your hair dry. And it ideally should be not freshly washed hair. Freshly washed hair doesn't hold curl and body the same as dirty hair, but not too dirty, Sarah. We're not talking about skipping like the whole week of showering, okay? Or washing your hair. We're talking about like one day to the next, okay? Those are my suggestions for makeup. Also, and this cannot be overstated enough, as Rachel Lee has pointed out, we need you to have tuning fork bangs because, as we know from Melanie Gibb, the tuning fork bangs be letting you know evil lurks. Okay? All right. There you go. For tonight, I feel like because it's Friday and it's the end of the week, work week for the court, and the evaluation or the deposition, excuse me, of the state's expert witness by the defense took place yesterday. I have a feeling, as Mr. J foreshadowed on Wednesday's hearing, dun, 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 that there will be a motion in limine. And I have a feeling, in fact, let's just go ahead and refresh the docket and see if it's up there yet. No. But I have a feeling it will be filed today. And that's why, Allie, I try to be a helper. Allie says, LOL, nice of you, Jen, to give advice. I do try to help. I try to be a helper. I do find that, the pretend judge has pointed out that aluminum would be contraband. Sarah can use toilet paper rolls. That's true. Although the problem, you're going to have to use some kind of stability with the toilet paper rolls. And here's why. Because what happens to cardboard when it gets wet? Yeah, not a good idea. So, Sarah excels at everything. Surely she will excel at jailhouse makeup and hair. Yeah, Music City Mom. I heard about it. I've looked into it a little bit, but I need to follow it a little bit more. There's a dock workers strike here in the Floridas, and I understand it, but I'm not I don't have an opinion just yet. Not ready. I like to think about things. So, what I predict is, let me see when this was filed. Because let's see, he filed at 7, okay, but not made 7:16:49 p.m. yesterday, which this is what I'll say. Last night, I am sure Mr. James Owens received a collect call from one Sarah Boone, no longer Esquire, as she now has an attorney. And she was livid when she found out. So there is that. And I have a feeling that things are not going to go the way that Sarah Boone wants them to go. And we all know what happens when Sarah Boone does not get her way. The letters start to flow in. And that is, I think, exactly what is going to happen. Now, I've started to try to talk about what I'm going to do tonight 20 times. So for all of you that are watching now and on replay who are like, bruh, Jen Lou, just say we're going to do tonight because we're ready to go. I'll tell you. Because of that, I feel that the state is going to file a motion in limine regarding those that testimony that Sarah gave and contradicting statements made at the Orange County Sheriff's or Orange County Jail. whenever Sarah was being evaluated by their witness, their expert witness, rather. I do think that we should revisit what Sarah has said in that testimony. I'm going to fix the audio. KPM sent me, thank you, babe, so much for that, sent me a link to better audio. And so what I'm going to do is take that better audio and make it, if I can, muchly better. There's not a whole, I mean, the mic situation is the mic situation, but I might could be able to fix it a little bit. So yeah. Shiv, no makeup. At first, Sarah thought she was going to get it, but sadly, hilariously, the judge, after speaking to an officer, said, no, Sarah, you cannot have the makeup. Sorry about your look. And I forgot what I was going to say about, so I had something else to tell you guys. Oh, yes. Just while I have you really quickly. So be looking for that tonight. I will go live at my usual time, which is 9 p.m. Eastern. That means 8 Central and 5 Pacific, I think. I'm not that great with time zones other than Eastern and Central. Mostly because I lived there. So yeah, that's the plan for tonight, because I really think that the things that Mr. J said in that hearing, I think they're repeating and really going over and talking about ahead of the trial, because we've all talked about what possible evidence could be left that we don't know about. And Mr. J stepped up to that podium and said, "Hold my hoops, I'm finna tell you." And he told us there is a video that was located on Sarah Boone's cell phone of Sarah Boone, allegedly, according to the state, coaching George Torres on things to say so that she would not get prosecuted. And lo and behold, she did not get prosecuted. So I thank you for letting it spilling just enough tea at the hearing, Mr. J, so that we were all of our ears perked up, and now we're wondering what's going to happen with that. So yeah, I think that's pretty much what we're going to do tonight. And maybe, depending on how long it goes tonight, maybe we'll do this. How about on Sunday night, if I gather all the letters that Sarah Boone has written over the years, and I do one last, until the next letter after things don't go her way, addressed to James Owens, Esquire. One last big, huge, dramatic letter reading. How do you guys feel about that on Sunday night ahead of the trial? What do you guys think? How would you feel about that? Let's see. KPM says, Jen Liu, was it on Sarah's phone? Some people think it may have been on someone else's phone. The way that I heard, what my ears heard, was on the defendant's phone. However, it's quite possible that during all the for the love of corn comments and bruh comments and the eye rolls at Mr. Owens. It is entirely possible that I heard it incorrectly. And that's why I really wanted to go over it again because I feel like it should be gone over again. Oh, thank you, Emily. That's so sweet of you. I appreciate that, babe. Thank you so much. That was very generous. Thanks, babe. Um, Thank you. So, how do you guys feel like about that? Yes, no, maybe so on the Shiv, have you heard me read the letters? I love okay, look, here's the deal. I love to read Sarah's letters because they're so freaking dramatic and like extra in the worst and best way at the same time. Okay, maybe this time what I will do, hey, Wayne Lewis, good to see you. Maybe this time, and thank you, Emily, for gifting a membership. I appreciate that. If you got the membership gifted by Emily, please thank her. How about we do it? How about I will take this suggestion. Lil Red says, only if you use the Sarah voice. Should I use the voice that she used while she was testifying? Should I read her letters in her? I'm on the stand and I'm very demure and very confused and I'm not a screamer. And look at me. I mean, despite the haircut, you guys, I'm totes not a Karen. Come on. I was confused and hung over from drinking 2 nights before. Come on, man. Should I use that voice? Or he was wearing his gun the whole time and it was very scary, officer. She talks like she you know, she reminded me a little bit of like Piglet from Winnie the Pooh. It's blustery Pooh. He had his weapon on him in the entire time, and I was in a confined space. I hate confined spaces. The irony. The irony. You're scared of being in a confined space. How the heck do you think George felt, ma'am? We know how George felt. He couldn't breathe, and he told you that like 11 billion times, lady. Tony. All right. So I'll read the letters and I will read it. I don't know. Uh, Nicholas says we need to get you an agent for voiceover acting stat. I don't know. Aw, creative minds. My dog loves your Piglet voice. It's I love Piglet. He's my favorite. Piglet and Eeyore. And I like Tigger. T-I-double-G. I'll mix it up. I'm going to put all my heart and soul into this last, until the next time, dramatic reading of Sarah Boone's letters. Yes, that's what I'm going to do. I'm going to read each part. I'm going to give it the drama it needs, the drama it deserves, the drama you guys want. I'll be there for you, I promise. We're going to have fun. We need to have a little fun before court on potentially the 7th. I will say this. I have looked, and both Law and Crime Network and Court TV have openings. They have a live scheduled for October 7th at 8:30, I think, a.m. Okay. So I'm going to schedule a live because at 8:30 a.m. And listen, maybe we'll be allowed to listen to some of the voir dire. I don't know. It depends. Sometimes it works. Sometimes they let us. Sometimes they don't. So we'll just wait and see. Okay. Wayne asks, can you also drop in a suitcase, Sarah? Bag it up. Boone, Karen voice also. Yes, I can, and I will. Whew. Hey, Doxy, the liar's table. Good to see you. Yeah, creative minds. I agree. I hope they get the audio fixed by then too. I promise I will help. I promise. I hope they get the audio fixed. I think what I was going to say is I bet you, I shouldn't promise because I can't promise something I literally have zero control over. I really think that because this trial is going to be watched by many, I do think that the local TV station that's carrying this stream is running the show is going to make adjustments. The hearings are a little bit different, so but I do think by trial time they're going to hopefully have all of the things worked out. Maybe they'll get up there and do a couple of mic check, 1, 2, 3, mic. Maybe they'll do it like gosh, it's Anna Gasteyer and Will Ferrell, who are the choir teachers. Ooh, hot mic, hot mic, hot mic. Ooh. I love that skit. So yeah. And I think that I think they'll be ready. And listen, we're just going to go with the flow. Whatever happens on Monday happens on Monday. We'll just get through it together. And I want to tell you guys, I know that there are a ton of people that are going to be streaming this trial, and you have a lot of choices of people that you can watch. And they're all good creators, really. And if you decide to watch it here with us over at the Ward, I would be very, very grateful and glad to have you. If you choose to bounce around, that's cool too. However, ever you want to do it. Low Red says, I think Jen Lou has watched SNL for too long. I've been watching Saturday Night Live since God, forever, really, since the late 80s, early 90s. I've been watching it, and I kind of stopped watching after like Will Ferrell and Sherry O'Terry and Molly Shannon and everybody kind of left. I kind of stopped watching after that. But as many of you know, or if you don't, you're new to the channel, one of my like lame human tricks is total retention of lines from shows, movies, song lyrics, stuff like that. Just trivia that, honestly, I don't know why it sticks with me, but it does. And that's all that I can do. So I will I can't help it. And it comes into my brain and it comes right out of my mouth, because if it doesn't, it will bother me all throughout the day. So yeah. Boy, okay, I want to ask one final question before we sign off. Okay. On a scale from 1 to sitting in an interrogation room, lean forward in your green chair, that obviously was an affront to you, being placed in the green chair, while you hold your finger and your thumb and your pointer finger together and underline the word no malicious. How mad do you think Sarah Boone is right now? On a scale from 1 to Sarah Boone's no malicious. How mad do you think she is? Wayne, Wayne says, if the courts had entry songs like boxers do before they enter the ring, Sarah's would be, I like the way you work it, no diggity, I got to bag it up, by by Blackstreet. No diggity. Now that song's going to be stuck in my head. Ah, she is the most mad. She's big mad, huge mad, gigantic mad, huge, bigly mad. No, don't be sorry. Listen, Wayne, I got to tell you, don't be sorry because during the day, 11 billion songs fly in and out of this brain of mine, and and I'll get stuck on a song. And so sometimes, and this will just be a new one to the repertoire for a while. Um, the ones that are currently in rotation are and constantly. Kyle's mom is one that's always in my brain at different times of the day for no reason. Um, uh, but recently, because of the book I'm about to start in Patreon reading, um, I've been listening to some Sid Vicious, and something else is in my head right now. She's so good looking, man. She's something else. So, yeah. Anywho, that's the deal. Oh, yeah, Wolf Girl, a mean ghoul, asparagus groupie Wolfie, who's got the Wolfie's asparagus is the angriest asparagus on the entire planet. Says, I have Millie Vanilli on repeat, so hopefully that kicks it out of my head. Thank you. And Robin says, Jen Lu, thank you for being my drive companion this morning. You had me guffawing all the way. God bless. Have an awesome day. Thank you, Robin. God bless you and have an awesome day. You too. All right. So I think now that I'm telling you, Millie Vanilli has been in my song too. That song has been in my head too. But yeah. Aw, thank you, Elizabeth, for being a member for 6 months. I appreciate that. Rachel Lee says, I'm right. I'm rewriting. Mama said, knock you out, starting with, don't call it a continuance. I've been here for years. I don't know if I can make that work. Hold on. Don't call it a continuance. I've been here 5 years. There you go. It's not even, I got to get it a little bit, We really need to be working on a rewrite for Good Day. Maybe I'll play around with uh, the beat to Good Day and do it for Sarah Boone, you know. Just dancing with the dog, no smog. Maybe we'll do something like that. All right, you guys. So we'll talk serious beeswax tonight. And then, whoa, 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 whoa. Aleda de Bruin says, I saw Boone's lawyer cannot practice law in Florida. So how is he able to defend her? Aleda, I'm going to have to look into that, babe. I've not seen that. And I want to vet it and find an answer because, I feel that would have been something that would have been caught. However, let me just say this. I have to agree. I think that the state would have caught that, and here's why. Because if he's not allowed to practice and then he does, and he represents Sarah in a trial, it wouldn't even matter what her charges were. Okay. But obviously, even second degree murder is a serious charge. It would leave her wide open for appeals and a new trial. And given the fact that the state, i.e., the taxpayers, hi, it's me, I'm a taxpayer, have shelled out so much money for this trial, for, as Sarah puts it, ongoing 5 years. don't know what you want me to say. Like, I don't. I feel like that is something that will be nipped in the bud. The document, okay. And Chastity says, saw it on Lawyer You Know. All right. So summa cum laude BSN, summa cum laude BSN, excuse me. Laude. I can't remember how you say that word. Summa cum laude. Yeah. BSN says he is delinquent on his fees. They could have been paid, but not updated in the system. Well, thank you, Christina T. New subscriber, enjoying your content. We'll join in tonight too. Good. I hope to see you guys there. I'm going to look into this. Now, y'all know I do enjoy the Lawyer You Know because he's local to Florida. And when he's also incredibly knowledgeable, and he does a fantastic job explaining things in a way that I can understand, okay? But yet doesn't say it in a way that comes off as condescending. It comes off as, okay, you guys aren't lawyers. Let me explain to you what this means. And he's not pretentious, and I enjoy that. So, and he doesn't take himself too seriously, and I like that too. I just like him. So I'll go over there and I will listen to that, and I will make a note of it. And we'll talk about that tonight. I will put that on the agenda. So we will reconvene at 9 p.m. Eastern tonight, and we're going to mention all the things, and then we'll have our Sunday send-off dramatic reading of all the letters, and we'll just talk. We'll just chill. It'll just be a chill night, just a place to kick it before trial starts. Monday, October 7th, 2024 at 8:30 a.m. Be there or be square. All right, I'm going to play the outro for you guys. And, oh, excuse me, coffee. My bad. I hate when that happens when you're talking and it just comes out. So rude. Pardon me, you guys. I'm going to play the outro. I'm going to end the stream, and I will see you all back tonight. What time? 9 p.m. Eastern. You guys have a great rest of your Friday, and I will see y'all tonight. Bye. Thank you all for being here. I appreciate all the support. Thank you so much. All right. For reals. I'm so sorry that I burped in y'all's ear. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious intent or effort was towards it.
No militia. Finish her!
Minutes later.
We all do a little math sometimes.
Man,